Okay, today is Sunday, February 17, 2013. There's a statement for the court requesting to go to trial. At the settlement conference in Stockton, California, Judge Grill, administrative judge, a personal request to go to trial due to the fact that on December 6, 2010, the dispatcher altered or falsified my logs beyond a reasonable doubt, and I have a witness to that fact that a statement was made to the Department of Transportation or the Highway Patrol officer, which works for DOT, stated that the logs appeared to be altered or whatever, and where are the rest of the logs, and I have a witness to that. So the incident happened on December 6, 2010. On December 7, 2010, he flat out sent me home because I received a notice of offer of work, good for 1 year, guaranteed. It was deemed accepted whether I turned it in or not. I went to work on December 3rd. On December 7, 2010, he flat out sent me home, and I was also on FMLA. I should note again that the incident happened on December 6, 2010. Okay, he altered and accused me of falsifying documents or logs or whatever. When he changed the time on my logs, taking the time from the second time clock in the driver's room and changing the time on my onboard automatic device that's in the tractor that is required by the Department of Transportation. He took the time from that second time clock and changed the time on my logs. And he wasn't supposed to do that, and he didn't make me aware of that. He did that. Okay, so the point is, the union attorney sent a letter that I was discharged on December 16, 2010. The Union Local 439 Teamsters of Stockton, California, it's a union shop, received the grievance on December 17, 2010. It's stamped. Received Local 439 on December 17, 2010. I should note that's 21 days from the date of incident. It took them 21 days to file a grievance. And they violated the contract in doing so. In fact, they didn't, they set a date and time for a panel hearing, which they set it for January 11, 2011, and that was James Williams, the transportation manager. In other words, what I'm saying is they didn't respond in 10, 20, or 30 days, according to the contract. And also, they didn't go to the Board of Adjustments, which they're required to do so because all discharges and suspensions are to be heard within 30 days. Within 30 days. And I should note that that didn't happen, and I should also note that the statement on December 16 by the union attorney that I was discharged on December 16, 2010 is not valid for the fact that the suspension and discharge didn't go to the Board of Adjustments, and there's no document stating that the discharge is to be upheld and signed by an arbitrator or Board of Adjustments, and signatures attached that who was present at the Board of Adjustments. No management or supervisory personnel is allowed to be on the panel of Board of Adjustments. They are not allowed to sit on that panel, and they have an arbitrator. And there's no document stating that the discharge is valid, and the fact that they violated the time limits. And I didn't receive any registered mail. I did not receive any registered mail within 10, 20, or 30 days. And they were supposed to respond within 21 days. I should note that December 6, 2010 to December 17, 2010 is not within 20 days. Now, making that statement, I should also note that there's 1,500 Teamsters employees there, and if it's not within the time limits, they are returned to work immediately with no questions asked. Well, it didn't happen for me. And also I should note to remind Judge Grill the fact that I received a notice of offer of work on December 1st, 2010. They were backed up by a report from October. I took a QME, and it said I had a permanent disability and that I could do my required duties on my job. I can do my work, in other words. And the notice of offer of work was backed up by a QME report, and that they were going to take 15% out. I should also note I didn't work one day on the Eureka Run 10 o'clock bid that I asked for on the notice of offer of work. And I should also note they didn't pay me every week or every 2 weeks since 3/21/2009. Okay? And I don't think we need to go any further. I'm requesting trial, and I also have a witness. Unless they can produce a document at the settlement conference to an administrative Judge Grill when I get my hearing date, and the fact that Judge Grill ordered a legal document that I have severe profound hearing impairment, that I'm deaf, and I haven't been accommodated with any listening device since 3/21/2009. And according to the legal document, I had a hearing problem since 2006. So I should also note that that Judge Grill ordered their two attorneys to get me a legal document, which I have in my presence right now. So they didn't return me to work like they did 1,500 other Teamsters. They didn't honor the notice of offer of work, and I was on FMLA. So we don't need to go any further. That's going to be my statement for the court. Long story short, I have a witness and I have documentation, unless they can produce a document from the Board of Adjustment stating from the Board of Adjustments and the arbitrator's name and signed, and also the signatures that he was present on the panel of the Board of Adjustment, that the discharge was valid beyond a reasonable doubt, and that they did respond within 21 days or 10 days or 30 days according to the contract, and that they followed contractual procedures. If they can't produce that, then I request to go to trial. It's a personal request from Julio Zamora, 1385 El Camino Way, Los Banos, California, 209-829-1787. And I also invoke double standards. Life is not fair, for the record. So that's my statement. A personal request to go to trial. Whenever I get my date from Modesto Legal Clinic, who's representing me. And when I get that date, this is going to be a personal request to the Administrative Judge Grill. And that's my notation for Sunday, February 17, 2013. And why is it taking so long to get a court date? I don't know. Anyway, that's my statement and the notation.